Hello and welcome to Triage, rapid legal lessons for busy healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Thank you for listening to Triage, rapid legal lessons for busy healthcare professionals from K&L Gates. These segments are designed to highlight timely issues affecting the healthcare industry that are important to our clients and friends of the firm. My name is Rebecca Schaefer, and I'm a partner in the firm's Research Triangle Park office. My practice focuses on helping clients with a variety of healthcare regulatory and transaction matters.
My name is Hannah Maroney, and I'm an associate in the firm's RTP office, also working principally on healthcare regulatory and transactional matters.
Thanks, Hannah. It's nice to be here virtually with you today. I appreciate the opportunity to discuss with you some HIPAA questions we've been receiving lately. As a string of recent OCR settlements show, the HIPAA Enforcement Agency appears focused on ensuring that hospitals within a health system, typically comprising a HIPAA-affiliated covered entity or ACE, have business associate agreements in place with their parent corporation. For background, it's common for the parent entity of health systems to provide shared services to their subsidiary affiliates, including IT support for a common EMR platform, accounting, legal, and other administrative services that involve access to PHI. We believe that whether or not a business associate agreement is required should turn on whether the parent entity is properly a member of the ACE, though the recent OCR settlements cast some potential confusion on the matter. In this episode, we will briefly review the most recent of such settlements involving Lifespan Health System, and then turn to some questions and answers related to these ACE organizational considerations.
Lifespan Health System, or Lifespan, as we'll call it during this episode, is a nonprofit health system in Rhode Island, which recently settled with the Office of Civil Rights for allegedly violating the HIPAA privacy and security rules. Among the covered conduct cited was the failure of members of the Lifespan ACE to have business associate agreements in place with their parent, Lifespan Corporation. Lifespan agreed to pay OCR over $1 million and entered into a corrective action plan, certain details of which we will get into as well. As is often the case, the matter began with a breach followed by an OCR investigation that included a broader compliance review. According to the settlement OCR press release, Lifespan filed a breach report in April 2017 describing the theft of an employee laptop. This breach was significant in terms of volume and scope because the stolen laptop was unencrypted and contained electronic PHI of 20,431 individuals, including patient's name, medical record number, demographic information, and medications. In their press release, OCR observed a, quote, systematic noncompliance with the HIPAA rules, end quote, by Lifespan, highlighting the lack of encryption even, quote, after Lifespan determined it was reasonable and appropriate to do so, end quote, as well as the lack of business associate agreements between Lifespan Corporation and its subsidiaries that make up the Lifespan ACE. The settlement agreement also notes that, quote, Lifespan did not implement policies and procedures to track or inventory all devices that access the network or which contain ePHI, end quote.
Thanks, Hannah. Our focus in this episode is on OCR's enforcement action with respect to the failure of Lifespan ACE or its member covered entities to enter into proper business associate agreements with their parent company. As folks know, covered entities are required under HIPAA to have agreements in place with their third-party service providers that assure these business associates will safeguard PHI in a manner consistent with HIPAA. Pursuant to the corrective action plan, Lifespan is now required to revise its policies and procedures to ensure compliance with the business associate agreement requirement. Lifespan must also provide these policies to OCR for review, along with an accounting and copies of all BAAs between Lifespan Corporation and members of the Lifespan ACE. I repeat, BAAs between Lifespan Corporation and the members of the Lifespan ACE, not the ACE itself as a single covered entity, something we'll take up in our Q&A in just a moment. This and recent similar settlements raise a number of questions for providers and other covered entities that are part of a larger health system, including how these organizations are permitted to share information between and among the parent and its subsidiary affiliate. We will take up a few of those questions here.
First, can you explain the significance of an ACE?
Sure. The HIPAA regulations at 45 CFR 164.105B allow covered entities that are affiliated but separate legal entities to designate themselves as a single covered entity for purposes of HIPAA compliance if they are under common ownership or control. One benefit of establishing an ACE is that it allows health systems to implement a consolidated and consistent HIPAA compliance program across their organization. Another is that since an ACE is a single covered entity for HIPAA purposes, it means that sharing PHI for healthcare operations or other administrative purposes between members of the ACE should be viewed as a use, not a disclosure, meaning that you don't need a business associate agreement between the entities, between the members. OCR provided support for this perspective in its preamble commentary to the Omnibus rulemaking in 2013. Specifically, in responding to a question about the sale of PHI prohibition, OCR said, quote, "The use of protected health information among legally separate covered entities under common ownership or control that have designated themselves as an affiliated covered entity, i.e. a single covered entity for purposes of compliance with the HIPAA rules, is not implicated. Thus, to the extent that what the commenters contemplate is an otherwise permissible use of protected health information within a single legal entity that is a covered entity or an affiliated covered entity, such use of data is not impacted by these provisions," end quote. Notably, an entity must first be a covered entity under HIPAA definitions to be a member of an ACE.
So as a covered entity and member of my health system's ACE, do I need a business associate agreement with my parent corporation?
Good question, Hannah. Is your parent corporation itself a covered entity and a member of the ACE? If so, our view is that provided the staff of the parent entity, such as the attorneys in the legal department, the auditors in the compliance department, provided they are workforce members performing legitimate job duties requiring access to PHI, this is permitted use as to all members of the ACE and not a disclosure, so a BAA isn't needed. The alternative would eviscerate the regulatory intent that an ACE be treated as a single covered entity. To illustrate, it would be like saying a single legal entity that is a covered entity has to have internal BAAs with its legal department, accounting services staff, etc., which we don't think would make sense. On the other hand, if the parent company is not a covered entity, it is ineligible to participate in the ACE. And to the extent it provides shared services or other administrative oversight that involves access to PHI, then a BAA is indicated. We're assuming that Lifespan Corporation, the parent entity, is not itself a covered entity and therefore not part of the ACE, and that's why OCR took the position it did.
As a non-covered entity parent of a health system, do I need a business associate agreement with each subsidiary covered entity that is a member of our ACE, or can I have just one BAA with the ACE?
Also a good question. In our view, a single BAA with the ACE that describes the services provided involving access to PHI should suffice. Again, this is consistent with the view that an ACE is a single covered entity for HIPAA purposes. That said, the parent may need or want multiple BAAs with the ACE to describe different sets of shared services, or may want one-off business associate agreements with individual members of the ACE if only those members are receiving a particular set of services.
But isn't it awkward to require that a parent company be a business associate of its subsidiary?
Potentially, since folks typically think of the covered entity in the business associate arrangement as controlling the relationship. But the business associate agreement can be framed to focus exclusively on HIPAA-required safeguards and not include terms that would suggest, for example, that the subsidiary hospital affiliate has the right to exclude the parent company from conducting compliance audits that necessarily involve access to PHI.
Does this guidance affect the relationships ACE members have with external vendors and subcontractors?
No, as these external companies would not be members of the ACE, they would be required to enter into business associate agreements before receiving any PHI. As noted previously, we believe the third-party business associate would not be required to enter into a separate agreement with each member of the ACE receiving that vendor's services, but rather the ACE itself as the single relevant covered entity for HIPAA purposes. Thanks, Hannah, for these thoughtful questions. For our listeners, K&L Gates Healthcare and FDA Practice is available to provide guidance to healthcare providers on these and other regulatory questions. Thanks again for listening to this Triage episode. If you have any topics that you would like to see discussed on Triage, you can either complete our survey linked in the show notes in the K&L Gates Podcast Center or email us. We'd love to hear from you.
Thanks again for listening to Triage, rapid legal lessons for busy healthcare professionals. New episodes are available for download through iTunes, Google Play, and other podcast applications. By subscribing to Triage, you will receive timely notifications of each new episode. Also, if you have any topics that you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.